Hello everybody, I'm Kat Langley. I'm from York St John University and I'm here to talk to you about my paper, Never Stare Directly at the Sun, which is a practical analysis of the relevance of the 1951 Refugee Convention. A little bit about myself in terms of brief background. So before coming to the world of academia and doing my PhD on refugee rights, I worked in immigration law practice for about 7 years. So this research really is driven by my curiosity as an ex-practitioner in this field, but also this paper arises out of some of the study around my PhD and related subject. So I'm just going to share the screen with you. I have a few slides. There we go. So as I said, my background has led to this curiosity-based piece, and hopefully I'm giving some insight into the practical application of international law here. So this paper is aiming to critically examine and evaluate the reasons why the convention relating to the status of refugees, the Refugee Convention, could be considered outdated at a practical level by current immigration practitioners. So further than that, this paper looks at some of the barriers raised by current immigration law framework in the UK, and it suggests in its findings that practitioners are really climbing a mountain in terms of the legal framework to support their clients. The title of the paper then came out of some of the empirical work I did in this study. One practitioner said that the Refugee Convention is like the sun. We all know where it is, we all know what it does, but we never stare directly at it. And I thought that this quote perfectly exemplified the interplay between the Refugee Convention itself and its practical application within immigration law in the UK. As an area of practice, immigration and asylum law is widely acknowledged to be really complicated and dense area, which is kind of in contrast to the Refugee Convention itself, which is relatively short and straightforward, and it gives some very basic elements in terms of protecting the rights of refugees, but it doesn't give us any background to how we should enact that. So one of the common problems, of course, with international law. The findings of this paper are really interesting because what we found in empirical study is that practitioners place a lot of relevance on the definition of a refugee under the convention, but actually after that, that's where their engagement with its provisions tends to stop. And in terms of their practical day-to-day jobs, much of the work that they do is limited by domestic policy and agenda. So this paper draws on interviews with 20 practitioners from across the UK, practitioners defining quite broadly, but most of our interviews were conducted with solicitors and barristers instead of other qualified legal executives. And they were between 40 and 70 minutes long in terms of what I did. And I also tried to cover various levels of seniority and geographical spread within the interviews as well. So this paper arises out of that research and follows three main areas of argument. So first of all, I look at whether the Refugee Convention is still relevant, 70 years old this year, and whether or not it is an effective living instrument. The second part of the paper then looks at the extent to which practitioners actually use that convention in their day-to-day. And as I've just alluded to, the findings are not very much at all. And then the third area within this paper then is to explain what is the cause of that lack of engagement with the convention. So I'm going to stop sharing with you for a minute while I talk to you about those issues. So from a practitioner perspective then, some of the practical limitations of the Refugee Convention, as we've said, are in the definition itself. So this is the bit of the convention which is most used, but actually it's the only bit which is really relevant to modern day immigration practice. So there is a lot of argument around the definition of a refugee itself under the convention, that it's actually out of date because it doesn't take into account modern day drivers of people's movement, including indiscriminate violence, for example, in Syria. Gender-based persecution isn't strictly included under the convention definition. Geological or climate-based issues which drive movement of persons across the globe. And so lots of the practitioners I interviewed wrote example of the convention definition, but there were one or two that kind of acknowledged that it's not really very useful in a modern day context. And what actually practitioners do is they shoehorn people into other catch-all groups under those convention terms. The UNHCR then contends that the convention remains the cornerstone of individual protection for refugees, even if it allows for quite a narrow and restrictive application. One of the other criticisms which is often levelled at the Refugee Convention is that there has now been a massive increase in the amount of global movement of displaced persons across the globe. And actually, as a policy issue, it's too costly for governments in social and economic terms to interpret that definition broadly. So it's quite an interesting consideration that is UK immigration as a framework doing all that it can do to support its signatory to the convention, that it should work with other states to do everything within their power to prevent refugees becoming a cause or a problem of tension between different member states. So, at least on a practical level, the only aspects of the convention which are often used then is the definition and some of the more technical non-refoulement and cessation clauses, which are only really relevant to war criminals and extreme cases in that respect. So for practitioners, as part of this empirical research that I undertook, the convention seems to have very little practical relevance, even if it's symbolically very important. So as I said, the next consideration of the paper then is how practitioners actually do use the convention. So as I said, the main issue in the use of the convention for practitioners is that definition. And all of the practitioners that I asked about their own definition, the vast majority of them relied on that convention definition. And a refugee under the convention is somebody who has been forced to flee his or her country because of a well-founded fear of persecution. And a refugee has that well-founded fear if it's for reasons of race, religion, nationality, political opinion, or membership of a particular social group, and they are unable to avail themselves to the protection of their state or internally relocate within that country. So the fact that most practitioners relied upon that definition, it does really show the weight of the history behind the convention and how established that definition is. But as I said, it doesn't factor in any of those social, political, ecological or cultural changes which have taken place since 1951. So when I asked whether that, those changes should be accounted for in an updated convention definition, most practitioners replied by just saying, well, they used what they were taught and they'd never given any consideration to the alternative. There was one or two that did reference some more outlier thinking and talk about geological and climate change issues which drive migration. But I think it's of real importance that the majority of participants interviewed relied on that convention definition. But they're very open about the fact that that's where their engagement with the provisions of the convention ended. So this project really suggests that the remainder of the convention has been subsumed and sidelined by domestic law and policy and agenda. And so the lack of engagement with it poses two important questions for me. Is it okay that practitioners only use the definition from the convention? And secondly, are domestic pieces of legislation and policy sufficient to enact the convention in the way in which it was intended? So if we look at the third element of this paper, then it's what can we learn about the reason for this lack of engagement? Well, in a nutshell, it comes down to the hostile environment that has been created by policy, by media outlets, and in people's attitudes to migration. So lots of my work as a practitioner, I found that there were lots of very negative opinions towards migrants themselves, migrants as a catch-all term. But actually, this research for my PhD studies and this paper has confirmed that actually it's much more entrenched than that. The hostile environment is one which is created not only in law, but in policy and also the court of public opinion. And it's one which is permeated and sustained by media outlets as well. So what can we do about all of that and make engagement with the convention better, make domestic policy better? Well, these are really broad questions, probably beyond the scope of this presentation. But it's arguable that if practitioners don't have the time to engage with, well, I've just used the law that I'm taught, then they're not likely to have the time or inclination to engage with broader questions about the theoretical framework in which they operate. So if I just reshare my screen for some closing thoughts with you. So it is possible then that the Refugee Convention as it exists, as it's used, is already redundant. And there's lots of literature on living instrument arguments. But from a practitioner perspective, if we just use the convention definition of a refugee, which is mirrored in national legislation anyway, then what's the point of the convention? Revoking the convention is likely to have actually little practical effect on a day-to-day basis for immigration practitioners. But of course, we're ignoring the symbolic relevance of this massive international piece of peacekeeping and the leviathan of international refugee law. So the symbolic effect of revoking the convention would be much larger. It is, of course, possible in the future that reform is likely, but in terms of the political landscape of hostile environment and activist lawyers, it's probably very unlikely. So the conclusion of this paper is really that the current system as things stand in the UK is ineffective at protecting the rights of refugees. And actually it makes the job of immigration practitioner much more difficult. It would be incredibly hard for them to do their jobs without the convention itself. So as practitioners, we should never stare directly into the sun, but life without access to any sunlight at all would be very difficult indeed. So I'm very happy to take questions, and I'd like to say thank you for listening and for your interest in this paper. Thank you so much.